And now to another important contributor to this event today. An established scholar, advocate and practitioner, Gillian Triggs. She's been United Nations Assistant High Commissioner for Refugees, President of the Australian Human Rights Commission, Dean of the Sydney Law School. Her 5-year tenure as President of the Human Rights Commission was, to put it mildly, difficult at times, as the Abbott and Turnbull governments sought to scale back the size of the Commission. Following this experience, she took up the position of Assistant Secretary-General of the UN and Assistant High Commissioner for Protection of the United Nations, High Commission for Refugees. During her appointment, she travelled to a great many countries and learned a great deal about the position of people displaced internally and externally. Today, it's our privilege to have Gillian Triggs share her insights with us.
Well, thank you, Joe, and thank you all for being here today. I cannot believe we have so many people willing to come and talk about these very important issues. And indeed, of course, we're here to commemorate the 125th anniversary, really, of Australia's gathered at the exhibition buildings up the road for the opening of the first Parliament of the Commonwealth of Australia under the Federal Constitution. And I'm reminded of that remarkable Tom Roberts painting, The Big Picture, which, as John has already said, represented a totally different world. I wish we had a formal painter, but presumably we can get a photograph of how different you are from what it was like 125 years ago. So well done. Thanks for being here. There are no more imperial feathers and no more ceremonial swords, almost all men. How wonderful to see such a diverse audience and many more women. Well, we are here primarily to continue the conversation which has started, to refresh, renew and reform our understanding of democracy, and to meet the contemporary challenges of globalisation, especially the rise in civil and international conflict, climate change, the millions of people seeking international protection across boundaries, threats to free international trade, pandemics and growing inequality and injustice. For in the 21st century, we've seen a decline in respect for the vital elements of democracy, but especially a decline in respect for the rule of law. But of course, this has never been perfect. I strongly support the efforts today to revive our commitment as Australians to the democratic ideal with civic education, understanding the principles of executive government, of parliament and an independent judiciary, and the principles of the separation of power through an increased local community participation in decision-making and international engagement. While the challenges to democracy in Australia are real, and I know other speakers will focus on these, but my focus is on the international rule of law as being of critical importance. For the health of our democracy in Australia cannot be understood only by reference to Australian issues. In our interconnected world, we must consider how the rule of law internationally can be strengthened to respond to global challenges. Indeed, it's no wonder at all that the decline in respect for the principles of democracy in national laws is reflected in international behaviour. But I'd like to go back for a few minutes, and some of you here will remember the foundations of that international rules-based order with the UN Charter, agreed in 1945 at the end of the Second World War by 51 countries, establishing, as it was necessary for the purposes of agreement, permanent representatives with a veto vote: China, Russia, the United Kingdom, the United States and France. But Australia, as a founding member, has been a serious member of that charter for many decades until recently. We also want to recognise, or I'd like to recognise, the foundational document of the Universal Declaration of Human Rights. The Doc Evatt was then, perhaps not always remembered, was the president of the General Assembly at that time as an Australian, and he really supported that Declaration of Human Rights and helped to support Australia's long commitment to an evolving rules-based order. But let's remember one of those fundamental principles of the Charter that's really informed the last 80 years or so. We, the peoples of the United Nations, determined to save generations from the scourge of war and to affirm fundamental human rights and the dignity and worth of the human person and the equal rights of all, we agree that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. Now, these grand words from the Charter have been the foundation for what became a phenomenal and unprecedented body of laws to promote international peace and human rights. The World Trade Organization bringing an end to the beggar thy neighbour policies of the 30s, lifting hundreds of millions out of poverty. The development of the UN agencies, the World Food Programme, the World Health Organization, the International Labour Organization, the protection of property rights, the Non-Proliferation Treaty, the treaties on genocide, on migrant workers, on women and aged people, the international covenants on civil and political, economic and social rights, and then the more ordinary day-to-day rules relating to the law of the sea and access to resources. But despite this optimistic and confident development of law in the 20th century, in the 21st, we've seen a significant weakening of the rule of law in our relations internationally, and they have declined. Today, there's a weakened respect for multilateralism, a retreat from those international obligations, very notably by the nations that negotiated, promoted and benefited from that global rules-based order. And there are many, many examples. But one that I think is most perhaps disturbing to me as a young law student here at the University of Melbourne and learning about the Charter has been that the optimism and vision of the UN Charter has crumbled as the Security Council has not been able to meet its primary objective of peace. It's been sidelined by ad hoc coalitions predominantly run by the United States and a reckless use of force by powerful states. We've seen the cynical and opportunistic use of the veto by the 5 permanent members that's brought the Security Council to its knees, largely sidelined from the conflicts in Ukraine, Gaza, Sudan, blocking the UN Charter principles for peace. We've seen a deliberate undermining of the United Nations and its agencies through drastically reduced budgets. We've seen chaos in relation to the WTO trade rules. We've seen a rise in civil conflicts, particularly in the Sudan, in parts of Africa, to the point that Pope Francis has observed that we're already in a third world war, albeit a fractured one. National security and self-defence are invoked selectively to justify egregious breaches of territorial sovereignty, and we see this in Lebanon, in Iran, Iraq, and Ukraine. In fact, I remember the last time I was in this hall was where we were debating the coalition of the willing's invasion of Iraq without Security Council authorization and without democratic discussion or approval, all done without the consideration of the Australian public. Contrary to the Geneva Conventions, also, citizens are the target of aggression in most civil conflicts and international conflicts these days. They are more than mere collateral damage. And we also see the consequences of climate change. We see China challenging the law of the sea. We see humanitarian crises with 130 million people under the United Nations Refugee Agency mandate. And we see rising movements of people forcibly displaced, compounding the populist nationalism, promoting the denial of refugee protection, rising anti-migration demands, now the leading international political issue for countries, including for Australia. Well, in trying to understand what appears to be the failure of international law and democracy and its institutions to reduce conflict and promote peace, we need to recognise that the world is a very different place today than it was when these grand ideas were first agreed by the international community. From the original 51 founding nations in 1945, there are now 193 sovereign members of the UN, many, as John's pointed out, achieving independence from colonial powers. The Democracy Index, compiled by the economist groups, estimates that there are only 26 of those 193 nations that are full working democracy, Australia being one of them. The remaining 167 members of the international community are listed as flawed democracies, including the United States, or they are hybrid or out-and-out authoritarian. The Secretary-General of the UN, Antonio Guterres, has said that the UN today is at imminent risk of financial collapse, with its agencies mortally wounded with underfunding. And Canada's Prime Minister Mark Carney, in his Davos speech, went further, declaring the end of the rules-based international order. Quoting Thucydides, "The strong can do what they can and the weak must suffer what they must," the very antithesis of democracy and everything that you're here to support. I do, however, believe that the Prime Minister Carney has gone too far. We should not be blinded by the illegal acts of rogue or maverick states, albeit immensely powerful ones. This is because it remains true today that the international rule of law is generally respected and has been over the last 80 years, mainly because it's in our mutual interest to do so. Most sovereign nations continue to see the mutual benefits of the rule of law and are finding workarounds, as you'll be aware, to ensure that these rules continue to apply. But international law fails spectacularly in restraining nations from aggression, where their perceived national interests are overwhelming. That's typically when we're dealing with territory, with borders, and with rich natural resources. And a notable example where I spent a certain amount of my time with the UN was the conflict in eastern DRC, Democratic Republic of the Congo, in North Kivu province, a conflict between that country and Rwanda. It's led to the displacement of 8.1 million people, essentially over the control of gold mines and lithium deposits, much of which finds its way to China. Well, all of that's perhaps rather abstract, and I'm an international lawyer, I love to talk about international law. But a practical example of the decline in adherence to international rules arises in response to the mass movement of peoples. UNHCR estimates that at the end of June last year, about 120 million people have been forced to flee their homes globally due to persecution, conflict, violence, egregious human rights violations, and in some cases, events disturbing public order. Among them, 42.5 million are refugees. While it's just one example of the adherence and decline in adherence to the international rule of law, refugee law has proved to be one of the most challenging and toxic issues globally that's led to a rejection of international law. And that brings me then to Australia and refugee policies. This country is a relatively successful democracy, as I've said. It's punched well above its weight, and I know this in the UN, in supporting international laws. In the early days, we were involved in drafting the Charter. Doc Ebbott played a very strong role with the Declaration of Human Rights, and we've played that role creatively and supportively all the way to the creation of the International Criminal Court at the turn of this century. We've been a strong advocate for GATT and the trade, and we have led much of the negotiations for human rights agreements, and most particularly the Disabilities Convention. We've been a global leader in protecting refugees. We've signed the Refugee Convention, and we have had one of the most useful and humane international refugee resettlement policies. But this all ground to a halt at the beginning of this century, 2001, with the Tampa affair, that reversed those policies and led not only to a denial of the principles of the Refugee Convention, the right to claim asylum, the right to education, to non-discrimination, to decent housing, to work, etc. All of those principles disappeared. But we also had an opportunity for executive governments to pass laws which are egregiously in breach of national laws as well as international laws. Australia has used its executive powers to a degree to deny the right to asylum, to detain refugees in isolated detention facilities on Nauru, Papua New Guinea and Christmas Island, including the detention of children for years without education, causing severe mental harm. Well, these are the realities of even one of the better and successful democracies in the world. So what are the solutions? One, of course, education and civic awareness. Another, the increased role of civil society. And I certainly saw this in my job through so many countries throughout the world, that where human rights policies, but particularly refugee policies, were implemented, it was usually or almost invariably local communities, faith groups, the various professions, teachers, local community groups, and the various international and national organisations. We need to encourage that local development and to strengthen democracy from the bottom up, rather than what we've seen, which is essentially the creation of these laws from the top down. And my final point is, and this is where I really land, that is that Australia is in dire need of a federally legislated Human Rights Act. Australia is the only common law country in the world that does not have some form of legislated or constitutionally entrenched charter or Bill of Rights. And that explains why the High Court in the Al-Kateb case could agree that a stateless man could be held in mandatory detention indefinitely when no other nation would accept him. It took the High Court 20 years to find a legal basis on which to overturn that decision just 2 years ago. And in a recent, and I mention only one because there are so many examples, but in a highly questionable effort to undermine the High Court, the Government of Australia recently passed a law termed colloquially as the Anti-Fairness Act, which denies common law rights to natural justice to people being deported to Nauru. It's a denial of basic human rights to due process under any democratic system, and it amounts to mandatory detention in a tiny island. Something that I think Australians would deeply understand, a denial of the basic idea of fairness. But I also believe that in this time of polarisation and division within the Australian society, a Human Rights Act can bring people together with common values of dignity, respect, equality and justice, providing processes to deal with divisions and ensuring accountability. In short, we should place the national focus on our harmony around those common values rather than identity. A Human Rights Act at the federal level, which can, of course, be repealed if it doesn't work. It's not like a constitution, but it can improve the lives of everybody living in Australia and provide a level of justice that we are seeing at state level in Victoria, ACT and Queensland. So in conclusion, democracy and the rule of law are under threat globally and in Australia. We see a fragmentation of political parties and a drift to extreme right and left views, leaving a vacuum in the sensible middle. Our meeting today is a valuable step to finding principled and pragmatic solutions that can reinvigorate our commitment to democracy and to the law, both within Australia and internationally. Thank you.
Thank you, Gillian, for bringing to the table and putting it at the centre of the table the whole question of human rights, international law, and what Australia could and should be doing. And as you've said, the 21st century, not so good so far.